Well, it is 11 o'clock, and so I will get started with the introductions and preliminary information. Welcome, and thank you for joining us at this webinar today for STEP Boston. To begin, I'll mention that this webinar is being recorded, and as you joined, you may have been asked to assent to the recording. If you have any concerns about being recorded, you may exit the presentation. We can't guarantee that this webinar will be available after the fact, but we can tell you that as a practical matter, no one is being recorded except if you place something in chat. So with that, I will begin this presentation. On behalf of STEP Boston, we are pleased to present Mr. Jan-Hendrik Frank, a German solicitor and certified specialist for probate and estate planning based in Berlin, Germany. Jan has been practicing in the area of international probate and estate planning since founding his firm in 2003. He speaks extensively on the area of the intersection of US, UK, and other international clients with German connections. He has written books, articles, and treatises on this topic, and he has founded and runs an organization for international attorneys. It is our great pleasure to hear today from Mr. Frank, and I will invite everyone as Jan is speaking, you're invited to place your questions into the chat, and if they apply immediately, I will raise them and bring them to Jan's attention. He has asked for questions, and we look forward to an interactive presentation. And in any event, more detailed questions can be held till the end, and we will have some time for Q&A after Jan's presentation. With that, Jan, I'll turn it over to you. Thank you again for being here today.
Ruth, thank you for the introduction. I'm actually specializing very much in German-American estate planning, and I will advise US residents and the estate planning attorneys nearly every day on the topic which we will discuss today. It's a complex topic, and nevertheless, I hope to be able to give you some understanding of it. At least you should be aware of the planning opportunities and the pitfalls of this situation if you ever deal with German resident beneficiaries. Okay, I've prepared a PowerPoint presentation, and I hope I can now. Yes, that works. So I would like to start with a case study, and I will the PowerPoint presentation will not make reference to it, but when we go through it, I will refer to that case study. Okay, I hope you will have some, you will be reminded by some prior mandates. This is supposed to be a standard estate planning, US estate plan. I've been advised that A and B trusts are no more the standard, but well, a trust and a disclaimer trust, when the disclaiming right is exercised, is very much the same, I would say. Okay, Mr. A. Smith is a US citizen permanently living in the US. He is married to Mrs. B. Smith, also residing in the US. The spouses have 2 adult children, B and D. Smith. All assets of Mr. Smith are located in the US. He transfers them during his lifetime to himself and his wife as co-trustees of his trust, and retains comprehensive rights in the trust assets. Right to revoke, right to amend the trust, right to defund it, transfer up, add trust assets to the trust, whatever. and of course also the interest in the income and the principal. Under the terms of the trust, 2 sub-trusts are to be created upon his death, and if he is survived by his wife, Trust A and Trust B, A, B trust. The assets in Trust A are to be held by the remaining trustee for the benefit of the surviving spouse during her lifetime, and she, as sole trustee, may make distributions to herself for health, maintenance, education, and support, hence standard. Upon her passing, the trust assets are to be distributed to the children in equal shares, outright and free of trust. The assets in Trust B shall pass to the spouse without any restrictions, outright and free of trust. Well, actually, trust for her benefit could continue, but well, I think under US laws, she would also be considered the owner of such a trust, right? Child B moves to Germany. Shortly thereafter, A. Smith dies and is survived by his wife. And now we will discuss what tax consequences that will have in Germany. You all know what tax implications it will have in the US, right? Okay, next slide. May I do that, Ruth, or you do that, right? Okay, great.
Yes, Anne will advance the slides.
Okay. Before we go into the special rules which pertain to trusts, or let me give you a basic an introduction to the basic general rules of German inheritance and gift tax system. Germany levies an inheritance and gift tax. It's a unified system, like similar to US unified system of inheritance and gift taxes. So, estate and gift taxes. So the same rules basically apply to inheritance and gift tax. Exemption amounts and tax rates in particular. Unlike the US estate tax, Germany taxes the acquisition of the beneficiary, and it's generally the beneficiary who prepares the inheritance tax return, and he always is the one who pays the tax, which doesn't mean that he may claim a refund out of the trust estate or the estate. Well, that's actually something you always should discuss with your clients when you draft an estate plan for them. Who pays the German tax? Many US instruments only make reference to estate, inheritance, and other transfer taxes. But does that also include the German inheritance tax? I think that's an important point which you need to discuss with your clients. Okay. The inheritance tax rates may sound low to you. Each child will receive up to 400,000 euro tax-free. The spouse will receive up to 500,000 euro tax-free. It's not totally tax exempt, the transfer to the spouse, like in US laws. But additional tax-free exemptions may apply, and because the tax-free exemptions are granted per transfer, it's more than you may think, because each child will receive from each spouse 400,000 euro tax-free. Each grandchild will receive an additional 200,000 euro tax-free, and transfers within a 10-year period are aggregated for determination of the tax. In other words, if the donor gives 400,000 euro and then lives for another 10 years and then gives another 400,000 euro, that's again tax-free. With regard to business assets, these may be completely tax exempt under German law. Okay, so the German inheritance tax is not as bad as it may look like, and you will receive a credit for any US federal estate tax paid, and also for state estate and inheritance taxes. So even in cases where the client is very wealthy, at the end of the day, no German inheritance tax or gift tax may be payable. Keep that in mind when you advise the client, or when you decide what kind of trust to create. Often it doesn't make sense to create a trust simply to avoid German taxes if you pay relatively high US federal estate tax, which could be offset against the German tax. Okay. Again, important to note, the tax-free exemptions are granted per transfer between two persons. And I explicitly refer to persons and not individuals, because that may also be the case with regard to more than one trust who qualifies as a legal entity under German law. There's no German generation skipping tax, so that's often also beneficial to give something to the next generation. Okay, Anne, Ruth, next slide, please. Okay, now I would like to give you a general introduction to the special rules which may apply to trusts. German law, Germany is not a trust jurisdiction, you may know that, which doesn't mean that a trust with regard to German assets is without effect. In fact, there are German equivalents and a US trust which also covers German assets, for example, because they are to be transferred to the trust by way of a pour-over will, are not without effect. But again, Germany is not a trust jurisdiction. But it has special rules for trusts. The German Inheritance and Gift Tax Act and other German laws do not refer to it as a trust. And these rules do not apply to all trusts. They only apply to trusts which qualify as foreign pool of assets with the purpose to bind assets. That's the definition of a legal entity for inheritance and gift tax purposes. For income tax purposes, there's a different definition. We will look at that later. Okay, what is a pool of assets? Well, that's basically everything which is not owned by the grantor or the beneficiary. So somebody needs to own it. If the grantor does not have comprehensive ownership rights, and the beneficiary doesn't have either, there is a pool of assets. In other words, when is the settlor grantor considered the owner? When he retains comprehensive rights? When is the beneficiary considered owner? Well, if he's basically free to do with the trust assets what you want. Let's have a look at our scenario. In the initial scenario, A retained comprehensive rights in the trust assets. So during until his death, he's still the owner and no pool of assets is in existence. That may change later. Trust B, for the benefit of his wife, will be funded upon his death, and his wife will have no limitations at all to use the funds for herself. She will be considered owner. There is no foreign pool of assets with regard to Trust B after the passing of her. Okay. Characterization may change. When will it change? Well, when it becomes irrevocable. When does the trust become irrevocable? Well, I think single trusts generally become irrevocable when the donor dies. If there are exceptions from that rules, I'm happy to discuss that with you. I'm not 100% sure if that is so. Or the characterization may change if the grantor relinquishes rights. So a trust which is not considered a foreign pool of assets may become a foreign pool of assets later. Well, that will be the case in our scenario once the grantor, Mr. Smith, A. Smith, dies. It will then be a pool of assets. It will also be a foreign pool of assets because it's governed by US laws. I did not say from which state he is. When is the purpose of such pool of assets to bind assets? Well, if the trustee, after the foreign pool of assets becomes in existence, is obligated to administer the assets for the benefit of the beneficiaries and not obliged to distribute them without delay, like an executor. So if you would draft a revocable trust in which the grantor retains all rights and would write into the trust document that upon the passing of the grantor, everything shall be distributed outright and free of trust. It will not be considered a foreign pool of assets with the purpose to bind assets. So you may use, no special German rules will apply to a trust. The only purpose is to avoid US probate administration proceedings. But the trust in our scenario is no such trust. Trust A is a foreign pool of assets with the purpose to bind assets because the surviving spouse shall hold it for her benefit and is not totally free to dispose of the trust assets. She may only distribute them to herself for purposes of health, maintenance, care, and support. So there are certain limitations of her powers, and that is sufficient, in my opinion, to make it a foreign pool of assets with a purpose to bind assets. So special rules apply to that trust. No special rules apply to trust B. Next slide, please.
Thank you. And Jan, a question has come up, and this may not be the right time for it, but the question relates to the timing of the German inheritance tax. It was asked, is the inheritance tax imposed as soon as the decedent dies, or is it imposed when the beneficiary receives the funds?
Yeah, well, if it is an inheritance and it is subject to German inheritance tax, it's triggered by the death, which doesn't mean that it is payable at the time of death. It will first have to be assessed by the fiscal authority. But you will have to report the taxable acquisition within 3 months after you receive knowledge of the taxable acquisition. In practice, that never happens and nobody cares. But we are lawyers, we have to be cautious. So advise your clients to report it without delay. Right? If it is subject to German gift tax and distributions from a foreign pool of assets with the purpose to bind assets are subject to German gift tax, the taxable transfer occurs when the distribution is made. So when the money is in the account of the beneficiary. Upon the dissolution of the trust, when the trust terminates and the beneficiaries receive the final distribution, the question arises, is the death the moment that triggers the tax or the actual distribution? And there has been a recent decision of the Federal Fiscal Court in which that was discussed. I will refer to that decision later. Maybe that's good to know for the auditory, for the participants, that I will go through the total lifespan of these trusts in the original scenario. So now, so we will start on the next slide with potential taxes triggered by the death of Mr. Smith and the funding of, by the death of Mr. Smith. We will then analyze what income taxes, if Germany may impose German income tax on trust income. Then we will look how Germany taxes distributions to the beneficiary. And finally, we'll look how Germany taxes the dissolution of the trust. And then I will also refer to that judgment. Come back to that judgment. Okay?
Yes, thank you.
Okay, great. Okay, special rules for foreign pools of assets with the purpose to bind assets. Of course, Germany will, first taxation of transfers to a trust. Hopefully that's not the case for your clients, and hopefully your estate plan avoids that. Why so? Well, Germany may tax that transfer to trust. Of course, only if there's a nexus to Germany, but well, where can the nexus derive from? Either because the grantor resides in Germany. In my initial scenario, that's not the case. They are US citizen permanently residing in Germany, but there may also be a nexus because the trust itself is considered to have a residence in Germany. When does a trust or foreign pool of assets with the purpose to bind assets have is considered a German taxpayer, a German resident? That is the case if either the registered office is in Germany, or you simply write into the trust document that the registered office is in the US. That's avoids this. Or it's also considered to be a resident of Germany if the place of effective management is in Germany. And that may be, or is generally the case, if the trustee is a German resident. So luckily, in the initial scenario, the trustee is not a German resident. But if you plan to nominate a German resident, for example, the child that moved to Germany, may not be a good idea, at least not to appoint it as sole trustee. If the child is only one of two trustees and the other trustee is a resident of the US, that may work. But as a matter of precaution, I generally recommend that no German resident should be trustee of a US-based trust. Why so? Because if it is considered a trust, the foreign pool of assets, to be a German taxpayer, Germany will tax the transfer to the trust heavily. It will be taxed in tax class 3, which is the most unfavorable tax class in the German inheritance and gift tax system. The tax-free exemption will only be 20,000 euro, and the tax rate will be 30%, the initial tax rate, and may go up to 50%. You may think that this is unfair that Germany taxes this, and isn't there a treaty which prevents Germany from doing so? Yes, there's a treaty, but it explicitly states that Germany may impose taxes on transfers to a trust, to a foreign pool of assets. Okay, and next slide, please. Okay, next part of the lifespan of the trust. Now the trust generates income, and the income is not yet distributed. It accumulates in the trust. But there's a German resident who is entitled to the income. Maybe either a discretionary beneficiary, so he may not have a claim for the distribution of the trust income, or also have a claim for the distribution of the trust income. If he has a claim for the distribution of the trust income and doesn't claim it, it may still be attributable to him, because under German special tax rules, under the German Foreign Tax Act, income of a foreign family pool of assets is attributable to the German resident beneficiary if he is entitled to the trust income. Interestingly or confusingly, the definition of a foreign family pool of assets is somewhat different than the definition of a foreign pool of assets with the purpose to bind assets. First of all, there's no requirement of the purpose to bind assets. So even a trust which simply has the purpose to avoid probate administration may be considered a foreign pool of assets. Even any state actually may be considered a foreign pool of assets, with the consequence that the income of the trust or estate may have to be determined in special German tax proceedings, which most tax advisors are not aware of, and many German tax authorities either. Even though it's not a very new law, in practice, it's not often applied. Okay, what is a foreign family pool of assets? A foreign family pool of assets is a pool of assets, and I've defined that before, to which the grantor, his relatives, in the meaning of paragraph 15 of the German General Tax Code, and or their descendants are final beneficiaries and intermediary beneficiaries with regard to 50% of the trust income or principal. Sorry for this sentence. I understand that one cannot understand it. It's probably not correct, but one cannot either understand the original of the German law. It's very broad and very obscure, and still many aspects remain unclear. What you should be aware of is that it will be attributable to the intermediary beneficiary of the income during the existence of the trust, if he is also remainder beneficiary. So even if he doesn't receive it, but he can expect that he will receive it when the trust terminates, the trust income will be attributed to him. And that's even so if he only is 50% remainder beneficiary. Of course, he will only 50%, in that scenario, only 50% of the trust income will be attributed to him. But again, even if it's not distributed to him. At that backdrop, I generally recommend to distribute trust income to the German resident beneficiary, because that may allow him to get a credit on the German tax at the time when the German tax occurs.
Yeah, and actually that raises a question that was posted in the Q&A.
Yeah.
Yes, Bruce Steiner asks, what if the U.S. parent's will provides for a German child in trust, but the trustees decide not to set up the trust and instead to have the executors of the estate distribute the child's share outright to the child? How does that impact the German taxation? Is that a good idea generally?
Well, if that is in the discretion of the executor to create the trust or not to create it, well, I think that would be honored by German tax authorities. So it would be simply subject to German inheritance tax if, under the terms of the will, it's to be distributed to the child unless a trust for the benefit of the child is to be created. That's fine, and that may avoid complicated German tax proceedings for the determination of the trust income. I recently advised trust beneficiaries of a New York trust in a similar scenario, which the participant just mentioned. And the trust called for the creation of a trust with my client, a German resident, as trustee. That was not a good idea, because that would have triggered, or arguably it would first of all, my client cannot be sole trustee under New York laws. And secondly, it may trigger German inheritance and gift tax on the transfer from the estate to the trust, or not. Well, the executor decided, well, I suggested at that backdrop to not to create a trust. Unfortunately, the executor decided to create a living trust under the laws of, I think, Indiana, and which I don't think is a good idea, but nevertheless he has done. And I told him, well, I don't think it's a good idea. The value of the assets held for the benefit of the child it was only about 200,000 euro. The costs in Germany for filing the tax returns will be a couple of thousand euro every year. That's not efficient. I don't think he has understood what I was saying. Maybe my English is too bad. I don't know why, but that trust is created, and
I wish I could
He was
use that.
anxious. He was anxious that the child would ever go after him once the child attains the age of 18. But I tell him what he's doing increases that risk that the child will go after him after it attains the age of 18. Okay, his decision. Okay, let's
Jan, I wish
continue
that I
with the
could.
presentation.
I wish that I could claim that my clients don't understand me when they don't follow my advice.
Okay, the taxable income, if it is attributed to the beneficiary, and again, may also be attributed to him if he doesn't receive it. It will be attributed to him if he can expect to receive it, either because the trustee may exercise his discretion to distribute it, or has done in the past, and because of that, one can expect that he will also do in the future, or because he's a remainder beneficiary. And how is that taxed? Surprisingly for many US advisors, that's determined under German tax laws. And what the most important aspect of that is that there's no step up in basis in German tax laws. So if you start to sell securities which are in the trust or in the estate, actually, that will have tax implications in Germany. And the taxable gain will not be the difference between the sales proceeds and the value as of date of death. No, it will be the difference between the sales proceeds and the acquisition value. So keep in mind, if you ever deal with a German beneficiary of a trust or also estate, whatever the executor does will have impacts in Germany if the beneficiary is a family member, or if it's a family pool of assets. And again, also an estate may be a foreign family pool of assets. The tax rate is not that bad. It's 25% plus solidarity surcharge and church tax if applicable. In my opinion, the special German laws do not override the treaty. In other words, if under treaty law, Germany is prevented to tax certain sources of income, for example, income from US real estate, that will not be taxed in Germany. It will not be taxed if the beneficiary would hold it directly, and it will not be taxed if the beneficiary receives the income by way of a trust. So that's good news. If you structure a trust, keep that in mind and consider to give to the German resident beneficiary assets which Germany may not tax. Or if there are securities, consider to allocate to the German resident beneficiary such securities which a relatively low appreciation in value. That will save German capital gains taxes when the securities are sold. And securities bought prior to 2009 even benefit from total tax exemption, though there's no German capital gains tax at all. Okay, and next slide, please. Okay, next part of the lifespan of the trust. Now the trustee starts to make distributions from Trust A. In the scenario discussed on the first slide, it was in the discretion of the trustee to make distributions to the spouse. Okay, let me slightly change it. So he may also make distributions to the German resident beneficiaries. So let's change the original scenario a bit. And let's say that's in his unlimited discretion. Would that trigger German gift tax if distributions are made after the trustee has exercised his or her discretion? Astoundingly not, because the Federal Fiscal Court has decided in 2019 and in 2022 that has been confirmed that an intermediary beneficiary, and Germany only imposes give tax on an intermediary beneficiary of a foreign pool of assets if he has a legal entitlement to the assets or the income of the trust, independently of the distribution decision of the trustee. Well, what does that mean, a legal entitlement? Well, one thing is for sure, if it's in the sole discretion, sole and unlimited discretion of the trustee to distribute something or not, he is not entitled to the trust assets. And the distribution to him or her is give tax free. Well, I recently dealt with a fiscal authority which took the entitlement from the fact that my client, the German resident beneficiary, was also a remainder beneficiary. I don't think that that is correct. So you see the German fiscal authorities try to narrow that decision down. Well, I've actually filed a lawsuit against that decision of the local fiscal court of Kusel, which was Rhineland-Palatia. And hopefully the fiscal court will overrule that. If you read the language of the decision, it's pretty clear that the fact that the intermediary beneficiary is also a remainder beneficiary should have no impact. But if you want to be on the safe side, structure the trust in a way that the intermediary beneficiary is not also the remainder beneficiary. How are the distributions from the foreign pool of assets taxed? Well, one may think, you may remember that the tax class is determined by the family relationship between the donor and the donee. So the trust and the beneficiary are not related. So you may think the least favorable tax class applies. Luckily, the law explicitly states that the tax class is to be determined by the familial relationship between the grantor and the beneficiary. So if in our initial scenario, the trust was created and funded by A, and the trust is for the benefit of the spouse and the children, that's tax class 1. So each of them receives 400,000 euro or 500,000 euro tax-free, if it is taxed at all. That actually could be distributed every 10 years tax-free to each child and each spouse. Well, I'm not sure if there are more than one spouses in US laws yet. There are in Australian law, actually. In Australia, you can have a spouse and a domestic partner, and they all receive the same tax treatment. Pretty surprising, I think. Maybe also upcoming in Germany and in the US. Okay, next slide, please, Anne. Okay, that's an important factor. Yes, there is I've mentioned that before, there is a treaty between Germany and the US in the area of inheritance and gift taxes. It doesn't prevent Germany to apply the special rules for trusts, but it may prevent Germany from taxation German resident beneficiaries. Well, when is a taxpayer a resident of the Federal Republic of Germany? Well, under German domestic law, you are a beneficiary if you have a dwelling and you use it more than occasionally. So that happens. You're quickly a German taxpayer. In income tax laws, there are treaties with nearly every jurisdiction in the world with regard which override that or which prevent Germany from taxing such residents. In inheritance and gift tax laws, there are very few, but luckily with the US, there is one. So Germany will maybe be prevented by the treaty to tax the German resident beneficiary, a beneficiary who has a residence in the meaning of German, in the meaning of the German General Tax Code. When may Germany tax him? Well, first, of course, if his domicile is in Germany. When is his domicile in Germany? That's determined under Article 4 of the treaty. If he is a citizen of the US and resident in the meaning of the German General Tax Code in Germany, we look at his permanent home. That determines the domicile. If he has a permanent home in both countries, we look at the center of vital interest. And in our scenario, initial scenario, he moved, the child C moved permanently to Germany. So I assume his center of vital interest, his sole habitual residence is in Germany, and also his center of vital interest. Does that mean that he is necessarily subject to German inheritance and gift taxes? Not necessarily, because Article 4, Paragraph 3 states that a US citizen who moves from the US to Germany and does not stay here for longer than 10 years is considered for treaty purposes to have a fiscal domicile in the US only. But German tax authorities, most German tax authorities think that this 10-year period only applies to the decedent and not the beneficiary. Why so? Because the law refers to the death of that individual. I don't think that that is correct. And I've recently filed a lawsuit with the fiscal authority in Berlin-Brandenburg, which is the joint fiscal court for Berlin and Brandenburg. And actually, Berlin authorities apply the 10-year rules also to the beneficiary, but Brandenburg authorities don't. So it came to the fiscal court of Berlin-Brandenburg because the tax was assessed by Brandenburg authorities, which is the neighboring state. And well, there's now a decision by the joint tax court of Berlin-Brandenburg. Hopefully, I have not spoiled the tax situation of my Berlin resident beneficiaries of trusts. They may not be, luckily that decision hasn't been published yet, maybe will never published. And I've also appealed against it, but the German Federal Fiscal Court may accept the appeal, may decide to take the case or not to take the case. And I fear that they will not take the case, so there may never be a decision on that question. And hopefully it will never be published. So you may still argue towards the Berlin tax authorities that the 10-year rule applies. In Bavaria, the situation is also very clear. They will not apply the 10-year rule with regard to the beneficiary. In other German states, it's not that clear.
I would love to hear more, but we are running short on time, and I know you have a bit more to discuss. So,
thank you for the reminder.
Yes, not a problem. We have many questions as well, please. That I'm holding the questions for the end because they go back into more detail. So.
Okay, so Germany imposes gift tax on distributions. Additionally, it may impose German income tax on distributions to the German resident beneficiary, but only so if that hasn't been attributed to the German resident beneficiary before. That also allows, again, the German resident beneficiary to offset any US tax. So I think that's actually beneficial, that rule. If it hasn't been attributed to the German resident beneficiary, it's taxed when it's distributed. It's taxed at a relatively favorable rate, 25% plus solidarity surcharge and church tax, but it's unclear whether the treaty benefits apply, because the German law under which the distributions are now taxed also applies to distributions from German corporations. And you may have dealt with that issue. Well, let's say if a German resident beneficiary received dividends from an LLC, and that LLC is from a German perspective a corporation, and let's say the underlying assets are real estate, you have created a tax trap for the German resident client, because now he receives dividends in the meaning of the treaty and no more income from US real estate. That's taxed differently. Now Germany can tax it. And the same may apply to this situation where the accumulated income of the trust is later distributed to the German resident beneficiary. So I generally recommend to distribute the trust income to the German resident beneficiaries, or what I also have recently dealt with is a trust where my client was not a beneficiary of the income at all. My client was only entitled to distributions out of the principal. I think that trust had been advised, has been structured by a German estate planner. I don't know who that was, but that was perfect. So my client receives distributions out of the principal. That's not subject to German income tax. And because that was a discretionary trust, not subject to German gift tax. Perfect. Good job, whoever has done that. Right. Okay, and next slide, please.
And Jan, before you move to the next slide, there was a related question. If there are German and US beneficiaries of a fully discretionary trust, how much income will be allocated to the German resident? Will there be a deemed allocation, or is that a situation where there might be no tax until there's a distribution?
Well, first of all, we would look if who is the remainder beneficiary. And if he would be a remainder beneficiary, that may be easy to decide that question. Let's say if he is entitled to 30% of the residue of the trust, 30% would be likely attributable to him. If he's not a remainder beneficiary, well, that's true. Well, we would look at how that is handled in practice. And if there is a pattern or something like that, they would probably also decide on the attribution for future income of the trust based on the pattern in the past. Right.
Thank you.
Okay, taxation of the final distribution, dissolution of the trust. That is always subject to German gift tax and not irrespective of whether, well, of course, he has a claim, the remainder beneficiary, to what he receives upon the dissolution of the trust. It says, oh, well, but that's always subject to German gift tax. That's important to understand because, well, consider to make more distributions during the existence of the trust that may avoid German gift tax. Once the trust is dissolved and the final distributions are made, it's clearly subject to German gift tax. The tax class is also determined by the familial relationship between the grantor and the beneficiary. And distribution during the existence of the trust within 10 years are considered in order to determine the tax. I think that's what one of the participants had asked me. When is the tax triggered? Very good question. Is it the death or is it the actual distribution? The Federal Fiscal Court has ruled that it's the time when the assets are effectually transferred to that person. And when that happens is a question of foreign law. Wow, if foreign law applies. With regard to living trusts, foreign law generally governs that question. With regard to testamentary trusts, not necessarily. In my scenario, it would, because the creator, the testator, would be a US resident. But with regard, let's say if the creator, the grantor, would be a resident of the Federal Republic of Germany, German law would govern that question. Okay, but let's say US laws govern that question. You know those laws better than I, but what does that mean when the assets are effectively transferred to that person? Well, I don't know the answer. But I think there's a lot of room for advisors to write something which satisfies German fiscal authorities. That decision is actually very beneficial for clients, for my clients. Why that? because that may give my clients the opportunity to move back to the US and by doing so avoid German taxes. Well, some of my clients before their parents die already asked me, well, can I do that? Well, you can do, but in practice, I tell you, you will not have the, you will have other things to do. But given this new decision, the trustee may decide, if he may do so under the terms of the trust, to withhold the share of the German resident beneficiary for a certain time period. And that may give the German resident beneficiary the opportunity to resettle to the US and take the time necessary for doing that, right? Well, that's a very interesting decision, but we will see how German fiscal authorities apply that decision. I think because it's a question that the German Federal Fiscal Court explicitly stated that this is a question which is governed by foreign law. This gives room, a lot of room to tax planning.
That's great. We do have several questions, but I know you have one more slide, so I'll hold the questions for just another minute.
Okay, that's the last point. Some of you may have come over Article 12 of the treaty, para 3, which gives the German resident beneficiary an election right. He may elect to be taxed just as if he had directly acquired the trust assets. That may be beneficial if there is relatively high US federal estate tax triggered by the death of the grantor. Because can you offset US federal estate tax against German gift tax triggered by the distribution from a trust? Not so sure. I actually don't think that that is possible. So if high US federal estate tax was paid, it may be beneficial to elect to be treated as if there has been a direct transfer and then offset US federal estate tax against German inheritance or gift tax. Okay, in our scenario, that election right would be available because the transfer to the trust is not taxed under German law. That's important. Well, again, don't appoint, or you may appoint, but the German resident beneficiary should not accept the office of trustee, or not, at least not sole trustee, because that may trigger German taxes on the transfer to the trust, in addition to the taxation of the transfer from the trust. Okay, but if it's the transfer to the trust is not subject to any German transfer taxes, you can exercise the election right if you wish to get a credit for the US federal estate tax on the German inheritance or gift tax. To all estate planners' surprise, German fiscal authorities have opined. That's a joint letter of all German fiscal authorities of all German countries, German states, that this doesn't mean that no German gift tax is triggered by the distribution. I don't know where they take that from. That's crazy. And if you ever deal with that situation, please contact me, and I'm happy to prepare a lawsuit against that. I don't think that that is correct. But if you have a German resident beneficiary, you need to be aware of that opinion of the German federal fiscal authorities. Okay, 5 minutes or 6 minutes to go. That's good time.
Perfect. Perfect. We have a question from an attendee who remains anonymous. And by the way, many thanks to Jen Flanagan and to Michael Van Size for presenting your questions earlier. I didn't attribute them at the time. So we have an anonymous question about the nature of assets. If a German client wants to establish a foreign pool of assets, so a trust, for a US beneficiary, and what they're putting into the trust is German-based operating a business, can that qualify for the business asset exemption from gift tax and also be free of inheritance tax issues in Germany in the future? So, and can it also be income tax efficient in Germany?
I must confess, I don't deal with so many active businesses in Germany. I'm focusing on private clients. Okay, I'm not sure if I got that correct. Okay, so the grantor is residing in the US, right?
So
And
this,
the
it looks
business
like
is in Germany.
it looks like we have a German, let's say we have German parent, and daughter is in the United States, and the German parent has a family business. They want to leave that business to their daughter. Can they place the business in a trust in Germany for the benefit of their US daughter in a manner that is efficient for gifts and income tax? Because you had mentioned that operating businesses were an exception, I think, to the tax rule.
Well, yes, and I also mentioned that Germany doesn't recognize trusts, which doesn't mean that they are totally ineffective. So the basic rule is that there cannot be a trust with regard to German assets. So if you try to create one, there will be a German equivalent. What are German equivalents? Well, it's a direct translation of German terminology, but a German executor may hold assets for a longer time period, for 30 years or longer. That's a trust, right? But we don't call it a trust. And it's not subject to these special tax rules. Okay, so because it's not a trust, not a foreign pool of assets, foreign pool, it will be a German, kind of German pool of assets. The special tax rules will not apply. Instead, the general tax rules will apply, and that also includes the exclusion for business entities.
Thank you. That's very helpful. And the person submitting the question did refer to it as a foreign pool of assets, but as you correctly point out, the assets are not foreign if it's a German operating company.
Correct.
Right. Roger Healy mentions very useful. Thanks, Roger. Let's see. Jim had a question. There's no last name, but he had a question with apologies.
Sorry, Ruth,
Yeah.
I would like to add one point.
Of course.
In this scenario where the grantor is a resident of Germany, it will clearly not work. But if, let's say, a US resident tries to title assets in Germany in trust, he cannot do so during his lifetime. Will not work. You cannot get a German asset registered in a German commercial register or German land register, and you need to do that. Otherwise, you will not receive ownership rights. Okay, but if you do that, let's say by way of a poor overall, that may raise, well, first of all, it will make estate administration more complex because the German judge will have to interpret the US instruments. And it also raises tax issues. As we just agreed, a German pool of assets is not a foreign pool of assets. So I would argue towards the German tax authorities, because there cannot be a foreign pool of assets with regard to German real estate. This is not subject to special tax rules, but the agent of the German local fiscal authority may opine otherwise. There's no guarantee that they will follow that argument. What I generally do in that situation is I present them with the German letters of administration, and they show they do not refer to a trust, they refer to a executor under German law, under foreign law, because they cannot be a trust. And I will not use that terminology at all, but I will have to file with the German tax authority a copy of the trust document. I will have to do that. So I never had difficulties with that situation, but may happen in the future.
This is exceptionally helpful. We do have a question. I believe you confirmed earlier that the slides can be made available to our participants. Is that correct?
That's fine, yeah.
Not putting you on the
I
spot.
think they are difficult to understand, so consider to read the articles on our website, which are linked on the last page of the presentation. And I think they will give you better guidance than I did in this presentation.
Oh, well, this presentation was exceptional, as are the materials on your website. And are you available for folks to contact you after this presentation?
Sure.
Wonderful. Well, thanks to all for participating. Thank you, Jan, for the lovely presentation. It was very helpful to me. I have quite a few notes, and I really appreciate this look into German law. Thank you.
Thank you.
That concludes our presentation. We'll look forward to seeing everyone at the next Step Boston webinar. Thank you.